There's a moment in this case that lasts about 2 seconds. A detective slides a photograph across a table, 2 drinking glasses on a nightstand. He asks a simple, almost boring question, "Which one did you pour the juice into?" And the woman across from him begins to answer. She says she poured the antifreeze. Then she stops, corrects herself, says she meant the cranberry juice. Detective Dominic Spinelli would later describe that moment to ABC's 2020. His colleague, Detective Valerie Brogan, watched it happen in real time and said it looked like the woman hurt herself. Nobody was arrested in that room. No confession was signed, but a case that had been drifting for 2 years suddenly had a spine, and it wasn't built out of chemistry. It was built out of a word. That's the part of the Stacey Castor case most retellings skip past on their way to the sensational headline. This wasn't a triumph of forensic science in the way people imagine forensic science working. Toxicology told investigators what had killed 2 men. They could never tell them who. What closed the gap was something far less glamorous and far more human. 2 detectives paying close attention to how someone talked. Why poison cases get lost? Start with the structural problem, because it explains everything that went wrong before it explains what went right. Homicide investigation runs on scenes. A scene gives you a time, a place, a physical interaction, a set of people who were nearby. Poisoning erases most of that. There is often no scene at all, just a sick person, then a sicker person, then a hospital, then a death certificate written by someone with no reason to suspect anything. And a death certificate is not a neutral document. It is a diagnosis, and diagnoses are shaped by expectation. Ethylene glycol, the toxic component in most automotive antifreeze, is a particular problem for that reason. Early on, a person who has ingested it can look intoxicated. Later, the picture shifts toward the kidneys and the central nervous system, and it can resemble any number of things a physician sees regularly. Standard hospital toxicology panels don't look for it unless someone specifically asks, which means the test that catches it usually only gets ordered by a doctor who already suspects it. That is the trap. In poisoning cases, you tend to find it only if you go looking, and you only go looking if something already made you suspicious. Hold that idea. It's the hinge of this entire story. January 2000, the death nobody questioned. Michael Wallace was 38 years old. He'd been unwell around the holidays of 1999, unsteady, having trouble with his speech seeming to come and go. His daughter Ashley, 12 at the time, later described coming home in January and finding him on the couch, making expressions she didn't understand. She was on the phone with her mother. She hung up and went to collect her younger sister from school. By that evening, Michael Wallace was unresponsive. He was taken to the hospital. He died. The cause recorded was a heart attack. Now sit with how ordinary that is. A man collapses. He's brought in. He doesn't survive. Cardiac events kill men in their 30s every year in every county in America. Nobody at that hospital was being careless in any obvious sense. They were doing what medicine does, matching a presentation to the most statistically likely explanation. 7 years later, detectives working an unrelated death would pull Michael Wallace's medical records and notice something that should have registered in 2000. His heart, on the record, had been normal. This is the single most important investigative lesson in the case, and it isn't about poison at all. It's about anchoring, the tendency for the first plausible explanation to become the frame that every later fact gets fitted into. Once heart attack was written down, there was no mechanism in the system to challenge it. No detective was assigned, no toxicology was ordered. The file simply closed, and a family buried a man believing they understood why. Cayuga County did not fail because anyone was lazy. It failed because nothing in the process required anyone to be curious. August 2005, a scene that asked to be read 5 years later in a house in the Syracuse suburbs, the second death arrived with far more scenery around it. On the afternoon of August 22, 2005, Stacey Castor called 911. Her husband, David, who ran a heating and air conditioning business, had shut himself in the bedroom, she said, and hadn't come out. She raised the possibility that he might harm himself. She described an argument that weekend, days after their wedding anniversary, in which he'd told her to leave and then warned her she'd regret it if she did. Onondaga County Sheriff Sergeant Robert Willoughby forced the bedroom door. David Castor, 48, was gone. What investigators found in the room was, in a sense, a complete story already assembled. 2 glasses on the nightstand, one holding a green liquid, a bottle of brandy, a bottle of cranberry juice, and beneath the bed, an antifreeze container with the cap off. Willoughby then noticed something in the kitchen trash, a turkey baster with droplets inside it. He pulled the bulb off and smelled alcohol. Here's the analytical point that most coverage of this case never makes. Stage scenes tend to fail not by containing too little, but by containing too much. A real event leaves an incoherent, partial residue. A constructed one tends to be legible. It explains itself, it anticipates the questions, it supplies a motive and a means and a mood all at once. Spinelli's instinct that things didn't add up wasn't mystical. He was looking at a room that had answered his questions before he'd asked them. And then there was the baster, sitting in the kitchen garbage, in the house. The problem with a fingerprint. The physical evidence came back, and it was suggestive rather than decisive, which is how physical evidence usually behaves outside of television. Stacey Castor's fingerprints were on the glass. Antifreeze was found in the baster, along with David Castor's DNA on the tip. Spinelli was candid with 2020 about the limits of that. The prints on the glass, he noted, were positioned as though the glass had been held from underneath, the way you'd hold it if you were tipping it toward someone. But he also acknowledged the obvious alternative. She lived there. She emptied the dishwasher. There is an innocent way to touch a glass in your own kitchen. That candor is worth pausing on because it cuts against one of the most persistent public misconceptions about criminal investigation, the idea that cases are cracked by a single item that proves guilt. Almost nothing in a circumstantial case proves anything alone. The prints on a glass are meaningless in isolation. So is a baster in a bin. So is a strained relationship. So is a will. What convicts is the joint improbability. Each fact has an innocent explanation. The question a jury is actually asked to consider is how many innocent explanations one household can reasonably require at the same time. David Castor's family, meanwhile, was refusing the offered story from the start. His ex-wife, Janice Poisson Farmer, contacted investigators to say plainly that she did not believe he would have harmed himself. His sister pointed out that he worked on cars constantly and understood exactly what antifreeze does to a person. His son, David Castor Jr., was left absorbing a different wound, a will that appeared to leave him nothing, which he initially read as a message from his father about how his father felt about him. That detail deserves more attention than it usually gets. Before it was evidence of a crime, that document was a piece of emotional damage inflicted on a young man who spent a period of his life believing his father had written him off. What the ground still held. Because they couldn't find a case in the room, investigators went looking for one in the past. They obtained Michael Wallace's records. They found the normal heart. And in September 2007, with a court's permission, his body was exhumed in Cayuga County. The science here is worth explaining properly because it's the one genuinely elegant piece of forensics in the case. Ethylene glycol itself metabolizes quickly. By the time most victims die, the parent compound may be largely gone, but the metabolic pathway ends in oxalate, which binds with calcium and deposits as crystals in tissue. Those deposits are durable. They persist in a way the original substance does not. Sergeant Michael Norton recalled getting the call from the medical examiner and being told the man was full of crystals. A death ruled natural in 2000 was reclassified as a homicide. Think about what that means in practice. The evidence had been sitting in a cemetery for 7 years, intact, waiting for someone to have a reason to ask. It hadn't degraded. It hadn't gone anywhere. The only thing missing for 7 years was a question. September 2007. The decision that revealed everything. Investigators were now closing in, and they were not being subtle about it. There were wiretaps, there were cameras. And significantly, officers went to Ashley Wallace's college to tell her what they now believed about her father's death. Ashley called her mother. According to Ashley's own account, given to 2020 in 2009, her mother suggested they have a drink together, that it had been a hard week. Ashley, 20 years old, thought that sounded fine. Over the following days, Ashley became severely ill. On the morning after the second night, her younger sister Bree, worried that Ashley hadn't come out of her room, went in and found her unresponsive. Stacey Castor called 911, reporting that her daughter had taken pills. Bree found a piece of paper that appeared to be a note. Ashley was taken to hospital. Doctors later said she had been close to death. She survived. Detective Brogan arrived to find a stretcher leaving the house and was handed the letter. She read it walking up the driveway and realized she was holding 2 documents in one, a suicide note and a confession. The note ran to more than 750 words. It was typed. It carried Ashley Wallace's name at the end, and it claimed responsibility for the deaths of both Michael Wallace and David Castor. Here is the analytical heart of the case. Up to this point, prosecutors had a suspicious pattern and no proof of authorship. The framing attempt is what created the proof. It was an act that required its author to produce a lengthy, original piece of writing under time pressure. And writing is the most self-incriminating thing a person can generate, because nobody can fully disguise how they use language. The note had an author problem. Several strands came apart at once. The document was on a computer, which meant it carried timestamps, and the timeline of its creation did not fit the young woman whose name was on it. Then, there was the vocabulary. The note referred to antifreeze repeatedly, and repeatedly dropped the final letter, rendering it as anti-free 4 times by the prosecution's count. Spinelli, reviewing it, recognized something. In his interview with Stacey Castor, she had said the same thing, same word, same truncation. District Attorney William Fitzpatrick later described the case as a prosecutor's dream precisely because it combined computer evidence, DNA, and forensic linguistic analysis. The discipline that asks the question, who actually wrote this? Some honest context is owed here, because it's the sort of thing a careful documentary should say, and most true crime doesn't. Forensic linguistics is not DNA. It doesn't produce probability figures. It relies on the premise that individuals have idiolects, personal patterns of spelling, punctuation, phrasing, and error, and that those patterns leak into anonymous writing. In academic and legal circles, the field has faced real criticism over the lack of established error rates, and courts have not always treated it kindly. But this instance was unusually strong, and it's worth understanding why. The feature wasn't a common typo. It was a specific, repeated, non-random truncation of a word that sat at the center of the case, and it appeared both in the disputed document and in the recorded speech of the person the state said wrote it. At trial, Stacey Castor offered an explanation for her verbal slip, that she'd cut herself off mid-word because another thought had interrupted her. Jurors were then asked to weigh that against the surviving daughter, who woke up in a hospital, was shown a confession bearing her own name, and told detectives she had no idea what any of it meant. The will and the people who signed it. The forgery charge is the part of this case that gets least attention and says the most about how ordinary people get pulled into other people's crimes. A will requires witnesses. Two friends of Stacey Castor, Lynn and Paul Pulaski, ultimately testified, under grants of immunity, that she had persuaded them to act as witnesses to a signing they had not actually witnessed. That is not a dramatic act. It is a small favor of the kind people do for friends constantly. Sign here, it's just paperwork. You know it's what he wanted. Nobody performing that favor imagines themselves as a participant in anything. Prosecutors use immunity in exactly this situation because peripheral participants are usually the softest point in a fraud. They have limited exposure, no emotional investment in the outcome, and, crucially, no motive to invent. Juries tend to find such testimony persuasive precisely because the witnesses are so obviously unhappy to be there. The document itself was charged as offering a false instrument for filing. Stripped of the legal language, she was accused of putting a fake will into the public record in order to inherit an estate. Prosecutors argued throughout that money, insurance, property, a business, was the through line connecting both deaths. The trial, a defense that needed a villain. The trial opened in Syracuse in January 2009 before Onondaga County Court Judge Joseph Fahey, with parts of it broadcast locally. Ashley Wallace testified as the prosecution's first witness. Her sister Bree testified as well. Defense attorney Charles Keller advanced the theory that Ashley was responsible for both deaths and had attempted to take her own life. Whatever one thinks of that strategy, it is worth examining as strategy because it illustrates a genuine dilemma in criminal defense. Keller's client insisted on her innocence, which foreclosed arguments in mitigation. The physical evidence pointed into the household. If it wasn't her, someone in that house had to be offered instead. And the alternative candidate was a young woman who had nearly died and was sitting in the courtroom crying. Defenses that require jurors to feel hostility toward a sympathetic victim almost never succeed. Jurors do not simply weigh propositions. They look for a story they can live with afterwards. Asking 12 people to conclude that the daughter did it and that her survival was luck rather than rescue was asking them to adopt a version of events with no emotional exit. Then, Stacey Castor took the stand herself and was cross-examined by the district attorney. Reporters noted she showed little visible emotion, including when the verdict came. That observation has followed the case ever since, and it deserves a caution. There is a substantial body of research indicating that people are poor at detecting deception from demeanor, and that flat or composed defendants are frequently judged more harshly regardless of guilt. Composure is not evidence. The case against Stacey Castor was strong on its documentary and forensic merits. It did not need her face, and neither do we. The jury, 10 women and 2 men, deliberated roughly 16 hours across 4 days. On February 5, 2009, they convicted her of second-degree murder, attempted second-degree murder, and offering a false instrument for filing. At sentencing on March 5th, Judge Fahey, who had spent decades in the system, told her she was in a class all by herself. Fitzpatrick said afterward that she would have to serve more than 51 years before becoming eligible for parole. The legal fight almost nobody covers. 2 appellate arguments in this case are more interesting than the crime itself. The first concerns the death of Michael Wallace, a death Stacey Castor was never charged with. In September 2008, Judge Fahey ruled that evidence about it could be presented at her trial for David Castor's murder. American law is generally hostile to that. Under New York's foundational 1901 decision in People v. Molyneux, the prosecution cannot introduce a defendant's other bad acts to suggest they are the kind of person who commits crimes. Propensity reasoning is barred. But there are recognized exceptions, including identity and distinctive method, and prosecutors argued the 2 deaths shared a signature specific enough to qualify. Appellate counsel Randy Bianco argued the opposite, that the evidence was overwhelmingly prejudicial, that the state had never proved who killed Wallace, and that no realistic jury could hear about a second poisoned husband and then set it aside. Both positions are reasonable. That is exactly why the rule is one of the most litigated in American evidence law. The second argument was narrower and, in New York, potentially explosive. Castor's later filings contended that police interviewed her at a point when she was represented by counsel. New York's right to counsel protections are broader than the federal standard. The state's so-called indelible right can attach earlier and be harder to waive. The dispute turned partly on whether the lawyer in question had been retained for the criminal matter or for estate business. Judge Fahey denied the motion in December 2013. A state appellate court affirmed in June 2015, effectively ending the challenge. What never happened? Michael Wallace's death was officially ruled a homicide. No one was ever charged with it. Fitzpatrick's public reasoning was practical. Given her sentence, she would very likely die in prison, so what would a second prosecution add? From a resource standpoint, that is defensible. From the standpoint of the Wallace family, it was not remotely the same thing. Relatives said publicly, years afterward, that they were still waiting. The Cayuga County had not moved. Michael Wallace's brother-in-law described the situation as frustrating and stuck. This is a cost that rarely appears in true crime storytelling. A conviction in one county does not deliver acknowledgement in another. For the family of a man whose death was misread for 7 years and then formally reclassified as murder, the absence of a charge left the record permanently incomplete. There was no trial where his name was the name on the indictment. A separate line of inquiry also went nowhere. In 2010, Fitzpatrick confirmed his office had looked at the 2002 death of Stacey Castor's father, Jerry Daniels. He had been cremated, his autopsy recorded natural causes, and the DA acknowledged the evidentiary problems were likely insurmountable. No charge was ever brought, and nothing was ever proven. It belongs in this account as an unresolved question, not as a fact. The label, the press called her the Black Widow. The nickname stuck to the point that it now appears in nearly every headline about the case. It's worth noticing what a label like that does. It exoticizes. It converts a defendant into a folkloric type, the rare, patient, feminine poisoner. And in doing so, it makes the case feel like an aberration rather than something with recognizable parts. But the parts were not exotic. Prosecutors argued the motive was money, insurance, an estate, a business. The instrument was a product sold in every auto parts store in the country. The concealment relied on the fact that busy medical and legal systems accept plausible explanations. The framing attempt failed for the least mysterious reason imaginable. The author couldn't spell a word consistently. Stacey Castor also gave interviews, including with ABC's David Muir, maintaining her innocence and saying she could never have harmed her children. Defendants who go on television before or around trial almost never improve their position. They create a fixed record of statements that can be tested against evidence. It is worth asking why people do it anyway, and the likeliest answer is not strategy. It's that they are trying to persuade the people who knew them. A footnote in a plastic bottle. One postscript belongs here, and it complicates the tidy version of the story. Ethylene glycol has long been recognized as a hazard because it is sweet and because it is everywhere. Beginning with New Mexico in 2005, states passed laws requiring manufacturers to add denatonium benzoate, an intensely bitter compound, to consumer antifreeze. By late 2012, 17 states had such laws, and manufacturers reached a voluntary agreement to add the bittering agent nationwide. That reform was driven overwhelmingly by concern for pets and small children, not by homicide cases. And its effects have been debated. At least one study examining ingestions in states that adopted the requirement found little measurable change. So the honest conclusion is a modest one. The product is different now than it was in 2000 or 2005. Whether that would have changed anything in a case where the substance was reportedly delivered to someone rather than chosen by them is at best, uncertain. Safety engineering protects against accidents far better than it protects against intent. Stacey Castor was found dead at Bedford Hills Correctional Facility on June 11, 2016. She was 48. Officials attributed it to a heart attack and reported no suspicion of foul play. She had served roughly 7 years and had maintained her innocence throughout. But the ending that matters isn't hers. Ashley Wallace lost her father at 12 to a death nobody examined. She lost her stepfather at 17. At 20, she woke in a hospital and was handed a document with her own name on it, accusing her of both. Then she testified against her mother, in public, on television, and then went on to build a life in central New York. The lesson the case actually offers is not about poison, and it isn't about an archetype. It's that the systems we assume are checking things frequently are not. A death certificate in 2000 closed a file that no one was assigned to open. The evidence stayed intact underground for 7 years, requiring nothing but a question. And when the case finally turned, it turned on something no laboratory produced, a detective who remembered how a word had sounded in a room. That's an uncomfortable thought, and it's the honest one. Attention is not a forensic technology. It's a habit. And in this case, it was the only thing that worked. Michael Wallace's death was ruled a heart attack in 2000 and reclassified as a homicide only after another man died the same way 7 years later. Should there be a mandatory review process when someone young and healthy dies unexpectedly at home, or would that create more problems than it solves? Let us know what you think. Cases like this remind us that some questions continue long after the headlines fade. If you found this documentary informative, consider subscribing for more carefully researched true crime stories. We'd also love to hear your thoughts in the comments below. Thank you for watching, and we'll see you in the next documentary.